At the conclusion of this lecture, you'll be able to understand unfair dismissal, including the procedure and fair and unfair reasons for dismissal. We will discuss the remedies available to those who have been subject to unfair dismissal and explain what is meant by redundancy. The statutory right was introduced in 1971. Today, the law is set out in the Employment Rights Act of 1996, which sets out in detail what are fair reasons and what are automatically unfair reasons for dismissal and stipulations to prevent the dismissal being handled unfairly. It can and frequently does occur without there being any breach of the employment contract. Claims are heard not in the courts, but in the employment tribunals. It occurs if an employee is dismissed from his job and the employer does not have a valid reason for the dismissal or has acted unreasonably. In order for an employee to be eligible in bringing a claim of unfair dismissal against their employer, the Employment Rights Act 1996 specifies certain conditions that must be met. In most circumstances, only employees with 1 or more years' employment with the same or an associated employer are entitled to bring claims for unfair dismissal. In addition, an employee with less than 1 year's service will be able to bring an unfair dismissal claim if the dismissal is for a reason related to the employee's trade union membership or activities, is connected with pregnancy or maternity leave, is for a health and safety reason, is because the employee has brought a statutory claim against the employer, such as a claim for unlawful deduction of wages, or has made a protected disclosure. An employee must prove that there has been a dismissal, and it was not for one of the 5 fair circumstances set out in the Act, or if it was that the employer did not handle the dismissal fairly. To defend a claim for unfair dismissal successfully, the employer will need to show not only that it had a fair reason for the dismissal, but also that it followed a fair procedure before carrying it out. As to the reason for dismissal, the legislation provides that there are only 5 potentially fair reasons as follows. Misconduct. To warrant instant dismissal, the employee's conduct must be more than a trivial mistake and must be of sufficient seriousness to merit the description gross misconduct. Examples of such conduct might involve assault, drunkenness, and dishonesty. Poor performance. Capability is defined in Section 98 of the Employment Rights Act in terms of skill, aptitude, health, or any other physical or mental quality, and qualifications relate to any degree, diploma, or other academic, technical, or professional qualification relevant to the position which the employee held. However, even in this situation, the employer must show that not only was the employee incompetent, but that it was reasonable to dismiss them. Redundancy. This is prima facie a fair reason for dismissal as long as the employer has acted reasonably in introducing the redundancy program. Illegal to continue to employ the individual in his current capacity, for example, if a driver is disqualified from driving. Some other substantial reason justifying dismissal. The above particular situations are not conclusive and are supported by this general provision, which allows the employer to dismiss the employee for some other substantial reason. As a consequence, it is not possible to provide an exhaustive list of all grounds for fair dismissal. If an employee is dismissed for any of the reasons listed below, the dismissal is deemed to be automatically unfair. This means that once the tribunal has established that the reason for the dismissal is one of these automatically unfair reasons, the employee wins the case. The main automatic reasons include a reason relating to pregnancy, childbirth, or maternity leave, a reason relating to the assertion of the right to paternity leave, adoption leave, or parental leave, a reason relating to the assertion of the right to time off for dependents, a reason relating to the assertion of rights under the National Minimum Wage Act 1998, a reason relating to the assertion of rights under the Tax Credits Act 1999, or because the employer has made a protected disclosure under the Public Interest Act. This list is not exhaustive. If an employee is successful in his or her claim for unfair dismissal, under the Employment Rights Act 1996, he or she could be awarded the following remedies: reinstatement or re-engagement. If ordered, the employer will have to take the employee back into his or her old job or a similar job, unless it can show that it is not reasonably practicable to do this. This is rarely ordered, as the relationship has usually come beyond the point of return. Basic award. This is calculated in the same way as a redundancy payment and depends upon the employee's gross weekly rate of pay, age, and length of service. Compensatory award. This is to reflect the employee's actual financial losses arising from losing his or her job. Usually, awards of between 6 and 12 months' salary are given. There is a maximum limit placed by statute, which is changing constantly to take into account market conditions. If the employment tribunal finds that, although technically an employee was unfairly dismissed, he or she has acted in such a way as to contribute to the dismissal, the employee's award of compensation will be reduced. Another of the most significant provisions contained in the Employment Rights Act 1996 is Section 136, subsection 1. The right of employees to be paid statutory redundancy payments. Under the Act, any employee who has 2 or more years' service and who is dismissed in a genuine redundancy situation is entitled to receive a statutory redundancy payment. A genuine redundancy situation only arises if an employer ceases or intends to cease to carry on the business in which the employee is employed at the employee's place of work, or to need the employee to do the kind of work he or she is employed to perform. Statutory redundancy payments are calculated on a sliding scale based on the employee's age, length of continuous service, and salary. Turning towards the notion of enhanced redundancy payments. Some employers operate enhanced redundancy payment schemes under which redundant employees receive payments in excess of the normal statutory redundancy payments. The calculation of such enhanced redundancy payments will vary from employer to employer. The remedy for redundancy is based on the statutory formula for calculating a redundancy payment, based on the age of the employee, the length of service with the employer, and the employee's week's pay. Under Section 98 of the Employment Rights Act, a redundant employee may have an additional claim against the ex-employer for unfair dismissal. If successful, he will be entitled to compensation. The employer will have to prove he acted reasonably and without bias when making his redundancy selection. This includes giving proper warnings to the relevant employees, adequate consultations, and proof of attempts to find alternative employment. A tribunal will take into account the size and resources of the employer. In conclusion, following on from the previous presentation, it can be seen that contracts of employment can be lawfully terminated quite easily at common law, provided the correct notice is given. The statutory position is a great deal more complicated. Unless an employer dismisses an employee fairly in accordance with the provisions set out in the Employment Rights Act, the employee will be entitled to sue the employer for unfair dismissal. Finally, employees who have 2 years or more service are entitled to payment if made redundant.